Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello, welcome to podcast number 73. Thank you so much for joining us. Don't forget that, as always, this podcast is available from the Mayor Brown website, from the iTunes store. Just search under Mayor Brown, and it's also on YouTube. And as always, I'll post links to the cases I mention on Twitter. So if you follow me, it's Nicholas Robertson at Nicholas ROBER11. Just think, 10 Nicholas Robertsons out there got in ahead of me. Anyway, in this podcast, we're talking about three cases. We've got a Supreme Court decision on contractual and discretionary powers, a case involving a High Court claim for damages for breach of contract and breach of database rights, and finally, the case about the Christian nursery assistant who is successful in her tribunal claim that she'd been discriminated against on the grounds of her religion after she had expressed to a colleague what she'd understood to be God's views on homosexuality. So, first case, Braganza and BP Shipping Limited. Now, this is a Supreme Court decision, and although the precise case relates to the decision by the employer not to pay death and service benefits to an employee, it's potentially of much wider significance to all employers. The background to the case is the chief engineer on a ship owned by BP Shipping Limited disappeared during the night whilst it was on a voyage. If he'd committed suicide, then no death and service benefits would be payable. Otherwise, there were no grounds for denying death and service benefits. The contract said death and service benefits would not be payable, quote, if in the opinion of the company or its insurers the death resulted from the officer's willful act, unquote. Therefore, it was highly relevant to try and determine whether or not he committed suicide. The employer set up an inquiry whose primary focus was to determine whether or not any onboard procedures needed to be altered in the light of his disappearance, and the report concluded that the likelihood was the chief engineer had committed suicide. And in coming to this decision, the report had relied on 6 separate matters, including, for example, referring to his expressed concerns about his personal financial affairs and concerns about the state of the ship. The report then seems to have been adopted by the senior manager at the employer who was in charge of deciding whether or not to pay out on the death and service benefits. And remember, the test was whether, in the opinion of the company or its insurers, the death resulted from the officer's willful act. So it was in the opinion of the company. Well, his widow sued, won in the High Court, lost in the Court of Appeal. The matter went up to the Supreme Court, and there were 2 separate questions. The first, what was the standard expected of an employer when it's exercising its discretion as to it forming an opinion about something? In particular, the Supreme Court was asked to consider whether the scope for challenging an employer's exercise of discretion was the same as the scope which applied when challenging the reasons of a public authority. There, in the public law arena, the concept of the Wednesbury unreasonableness test is well established. Well, the Supreme Court accepted the Wednesbury test should be applied here. In particular, the Supreme Court accepted that the courts were not to rewrite the contractual bargain entered into between the parties. However, the process by which an employer decided how to exercise its contractual discretion had to meet 2 tests. First of all, it's necessary for the employer to establish that the right matters have been taken into account before the decision has been come to. Secondly, the decision should not be one that no reasonable decision-maker could have reached. Now, then the court went on to consider whether the evidence of suicide was sufficiently substantial, and here the Supreme Court split 3-2, but on balance took the view that it was not, that there wasn't sufficiently cogent evidence. And the argument which was accepted by the Supreme Court was that the more unlikely the factual finding was, the higher the need for cogent evidence. The finding of suicide was an inherently improbable finding, for reasons such as the fact the employee was apparently a devout Roman Catholic, for whom suicide is viewed as a sin. So therefore, on the facts on this case, there was a need for cogent evidence. I don't propose to say any more about that issue, that second issue. The reason I really wanted to mention the case, though, is that the rulings by the Supreme Court are potentially very significant and far beyond the sad facts of this case. The courts have for some time accepted that there can be a degree of control implied onto an employer's exercise of discretion. Clark and Nomura, for example, dealing with a bonus case, thought in terms of irrationality. Was the decision one which no reasonable employer could have reached? But this is the first case that I'm aware of where the Wednesbury test has been applied in this way to the exercise of an employer's discretion. In particular, the employer in this case argued that only the second limb of the Wednesbury test should apply, i.e. the decision was only capable of being challenged if it was one that no reasonable decision-maker could have reached. However, the Supreme Court was unanimous in deciding it was also open to an employee, or in this case the estate of an employee, to establish that the right matters had to be taken into account before the employer came to its decision. And this, I think, clearly opens the way for more challenges to the exercise of the employer's discretion, although there may be a slight sting in the tail, as I shall explain. Additionally, given that it is unlikely that there are going to be any significant extension to statutory employment rights under the current government, I think this case indicates that judicial activism may yet be a source for the growth of employee rights in the foreseeable future. I think it's unlikely that the government will extend rights, but a case such as this does create additional ways of challenging the exercise of an employer's discretion. I suppose it may mean that there's scope for employees to develop their rights even during the lifetime of the current government. However, and this is the sting in the tail I mentioned a moment ago, I think this raises the issue once more of whether an employer could exclude the implied term, or the implied limitation. The court here was very clear that it's not up to the courts to rewrite the contractual bargain between the parties. Fine. It's contractual orthodoxy that terms can only be implied if they do not contradict express terms in the contract. Therefore, what is to stop an employer from putting a general clause into its contract to say that, when exercising its discretion, there are no circumstances in which terms or restraints can be implied into the exercise of its discretion? I suspect we're going to see cases on this before too much longer. Indeed, it's something we've been looking at about how you would go about formulating such a clause. I'm sure as well that it would be potentially quite unpopular in the courts and with some employers that would say they are happy to have their the exercise of their discretion evaluated in this way. But overall, I think if you had a clause like that, it would be a significant extension of contractual principles to allow the courts to override an express clause setting out expressly the ambit of an employer's discretion. Anyway, that's the case of Braganza and BP Shipping Limited. Next case, Intercity Telecom Limited and Solanki. This is a High Court decision dealing with the outcome of a claim for breach of confidence, breach of contract and breach of database rights. I thought it was useful because it shows the way in which the court approached this issue, given that Mr. Solanki, the defendant, was found to have acted in a particularly inappropriate manner. Facts are relatively brief. He worked for Intercity and eventually got to the level of national account manager. The court found that relationships with customers were key to the business of Intercity, and it's one of the largest independent communication service providers in the UK. Well, Mr. Solanki left their employment, and shortly afterwards his former employer applied for and was granted an order requiring the delivery up of data and property and customers belonging to the employer. The court found at the full trial that Mr. Solanki's compliance with this interim order was incomplete and he had dishonestly sought to cover his tracks. The court decided at trial, which, by the way, Mr. Solanki elected not to attend to defend himself, that customers belonging to the former employer had been solicited in breach of post-termination restrictions and in breach of his obligations whilst he was still an employee. The court also found there was a breach of the employer's database rights. These are set out in the Copyright Designs and Patents Act 1988 and the Copyright and Rights in Database Regulations 1997. The court very quickly found that he'd broken his contract of employment, both the express terms, and he'd broken his duty of confidentiality because he'd used documentation, information and client lists belonging to his employer to go after his former employer's business. He'd also acted in breach of the employer's database rights because he'd effectively created a copy of the database, which was a composite of a number of other databases belonging to the employers, which he'd accessed for inappropriate purposes. As such, he was acting in breach of the database rights belonging to the employer. The court was asked to award compensatory damages, and there are relatively few cases where the courts get to the stage of awarding damages for breach of contract, breach of duty of confidentiality, and database rights. Well, the court approached this on the basis that it awarded a single lump sum for all the breaches. The employer was able to assert that there were specifically named clients from whom it believed it had lost income due to Mr. Solanki's actions. And the court, as I say, awarded a single lump sum in respect of all the losses covering all these heads: breach of confidence, contract, database rights, etc. And it did so in relation to clients for whom there was quantifiable loss caused by Mr. Solanke's actions. Bear in mind, of course, that Mr. Solanke was not around to argue that these people would have left in any event, irrespective of his wrongful actions, merely because he had left. Anyway, the sum of damages came to $290,000, but interestingly, the court went on to volunteer that the breach of the database rights was so serious because they had been, quote, furtively ransacked, unquote, by Mr. Solanke while still an employee, that the court would have added an additional 10% onto the damages, in effect as a form of punitive damages, for additional damages awarded in respect of breach of database rights. Cases involving damages awarded for breach of database rights are still relatively rare. I think I'm right in saying that we did the first case some years back, the Penwell case, where database rights were relevant. But overall, the case is a really useful illustration of the options open to an employer faced with a departing employee who has tried to take material with him. Obviously, most employees, once caught, don't take the steps Mr. Solanke was found to have taken in this case. They hand back the material. However, the reference to the database rights for additional damages payable for breach of those rights is very helpful. It shows that even in cases where it may be quite difficult to show direct provable financial loss, even though wrongdoing has occurred, this shows there may be a penalty imposed on an individual who has stolen material contained in the employer's databases and then used it against the employer. So third and final case, and forgive me, I'm not sure how I pronounce the surname, but I'm going to say it's Mumbai, which is M-B-U-Y-I, and New Park Childcare. This is the Employment Tribunal case, which has received a fair amount of press because the tribunal found that a Christian nursery assistant who had been dismissed by the nursery had been dismissed on the grounds of direct and indirect discrimination on the grounds of her religion. Although it's only an Employment Tribunal decision, so it's not binding, and the facts are odd, and the tribunal decision is a bit hard to follow in certain parts, I think the case is worth bearing in mind, particularly because it's had so much publicity. The background was that the individual worked as a nursery assistant. She's a Christian who attends an evangelical church. The central discussion which led to the problems was very unclear, but in essence it seemed that at work the claimant referred to attending church over the Christmas period, and her work colleague asked her about this. Now, the work colleague has been granted a permanent anonymity order because of references to her personal life, so we don't have a name or anything like that for her. I'm just going to refer to her as the work colleague. Anyway, the work colleague is a lesbian and living with her civil partner. The claimant, on her version of events, became aware that the work colleague was gay, and in response to a question about her own faith, said that, quote, God was not okay with what you do, unquote, but then went on to add, quote, we are all sinners, unquote. The work colleague became upset, and although initially only asked to be transferred to work in another room, attitudes on her part seemed to harden over a few days. Claimant was then dismissed on the grounds that what she said was discriminatory and wholly inappropriate. Her earlier gift of a Bible to the work colleague was also held against her. Claimant sued her employer, claimed harassment, direct discrimination on the grounds of religious belief, and indirect discrimination. The harassment claim was dismissed on the unusual grounds that the claimant had welcomed the questioning, therefore it wasn't unwanted conduct. However, it was the findings of direct and indirect discrimination that caught journalists' eyes. The tribunal found that there were manifest failings in the investigatory process and reasoning of the employer leading up to the dismissal. Certainly, the full tribunal decision goes to town somewhat on the inadequacies and illogicalities of the employer. However, the individual did not have a claim for unfair dismissal because she had not been employed for long enough. Therefore, the question was whether these findings could be translated into the discriminatory field, and in particular, whether she would be discriminated against on the grounds of her religion. Crucially, as well, the employer said that it accepted the claimant's version of events, which is why it had not troubled itself to follow up on investigating some of the points where her evidence differed from that of her work colleagues. In the circumstances, the tribunal felt that the approach adopted, the illogicalities of some of the questions, and the unfairness of some of the procedures by the employer probably betrayed stereotypical assumptions about evangelical Christians which were unjustified. I think by this, it might be that the tribunal is referring to the assumption that an evangelical Christian would be the sort of person who would offensively and inappropriately assert their disapproval of those who did not live life in the same way as they did. As I say, this was the assumption the tribunal seemed to feel the employer was making about evangelical Christians, And certainly when one gets into the stage of making assumptions about the way people behave based on sex, ethnic origin, religion, etc., you see it's a very short step to finding that there are discriminatory attitudes involved against that person. The tribunal did not think that a secular comparator would have been treated in the same way, and therefore it said that the treatment of the claimant amounted to direct discrimination. They pointed out that if the discussion about religion at work was inappropriate, it was surprising the work colleague, who on the claimant's version of events had initiated the discussion, that she had not even been involved in any formal disciplinary action. The tribunal then went on to uphold the claim of indirect discrimination as well. There was a provision, criterion or practice which was applied by the employer, which said that employees should not voice adverse views of homosexuality or treat homosexuality as a sin. This requires objective justification because it meant that evangelical Christians who believed it was a sin were placed at a disadvantage. Given that the absolute ban had not been explained to the claimant in advance of her starting work, and an absolute ban was over the top, the tribunal felt that the dismissal was not a proportionate means of achieving a legitimate aim. So what do we learn from this case? Well, commentators have for some time wondered about the hierarchy of discrimination rights and whether the rights of a homosexual employee not to feel discriminated against outweighed the rights of the religious employee who believes that homosexuality is a sin. The answer is there's no such hierarchy of rights. Equally, conflicts of this nature, where both sides have firm views and a legitimate expectation of protection under the equality laws, are the most difficult ones for an employer to deal with. Thirdly, if you find yourself in that area, it's essential to plan ahead and to conduct a scrupulously fair investigation. Overreacting one way or another, particularly on the basis of stereotypical assumptions about behaviours, is extremely dangerous. Finally, you have a much better chance of showing that the dismissal to enforce a policy is an appropriate step if you've tried the alternatives. Fortunately, I think in most cases people will reach a compromise as a way of continuing to work together, and it's relatively rare, for whatever reason, to find one or other side so intransigent that you end up with cases, such as the current tribunal case. So that's the case of Mbai and New Park Childcare Shepherd's Bush Limited. Finally, two quick points. I'd like to say thank you to Julia, who emailed me over the weekend to say that she had started listening to the podcast and was finding them very useful. So thank you very much indeed for that kind feedback. It's one of the pleasures of this podcast is I get emails from all over from people who I've not met, who I've got no particular connection with, haven't worked with them, and they take the trouble to write in. So thank you very much. Julie was even kind enough to say that she liked some of the musical recommendations. Well, I've got some good news on that front too. Between now and the 1st of August, I have 4 festivals that I'm off to, so I'm absolutely sure I'm going to come back with a load of recommendations and maybe a story or two as well. So the only other point to mention, other than to say, of course, thank you for listening, and the next podcast will be in 2 weeks' time, is to encourage people who have areas of operations in Turkey to listen to the special guest podcast that we did that went out earlier this week with Irmak Dirik. Irmak was a very engaging guest on the podcast, told us a lot about an introduction to Turkish employment law and some of the areas Turkish employment law differs from the sort of things that you and I expect. So give that podcast a listen. It can be located and accessed in the normal way. Once again, thank you very much for listening. Look forward to speaking in 2 weeks' time. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.